The Constitution of India enshrines freedom of speech and expression as a fundamental right guaranteed to all the citizens under Article 19. The preamble of the Constitution also outlines that the citizens of India have liberty of thought and expression. So, if you have ever wondered as to what is it that allows you to hold your opinions and express them freely without the interference of the state, it is the fundamental right of freedom of speech and expression. It is this fundamental right that allows you, for instance, to publish articles and books, post status, tweets, and comments on social media, to participate in public protests and demonstrations. Most importantly, it is this fundamental right that allows you to receive information from public authorities that is available on records. In other words, freedom of information is also protected as a fundamental right under freedom of speech and expression. Interestingly, the first law related to right to information, or RTI, was passed in Sweden in the year 1766, and the same was largely motivated by the Parliament's interest in access to information held by the king. In India, the law relating to the RTI is governed by the Right to Information Act, which was notified in the year 2005 with the twin objectives of curbing corruption and promoting accountability in governance. The RTI Act mandates timely response to a request for information from a public authority. For over a decade and a half, this important piece of legislation has been used to fight corruption and expose corruption and irregularities at higher level, such as the Adarsh Housing Society scam, the 2G scam, the Commonwealth Games scam, to name a few. It has also allowed a common man to access information held by a public authority without having to pay a bribe. Thus, for somebody like you and me, it is pertinent to understand the definition of information as well as public authority under the RTI Act. To put it simply, information covers anything that exists in any form with a public authority. Section 2F of the Act illustrates the broad scope of this definition by including records, documents, memos, and even emails. Section 2H of this Act defines as to what constitutes a public authority. The definition consists of two parts. The former part provides that a public authority includes body established by the Constitution or by any law made by the Parliament or the state legislature. The latter part covers bodies established by a notification or order issued by the government and includes a body owned, controlled, or substantially financed by the funds provided by the government, and non-governmental organizations substantially financed by the funds provided by the government. Therefore, the Indian Olympic Association, for instance, was held to be a public authority under the RTI Act on account of substantial funding by the government, not only for the discharge of functions of the association, but also for construction of its building. Similarly, a private recognized school could also be a public authority under the RTI Act if it is substantially funded by the appropriate government or it is under its control. What is pertinent to note here is that the three conditions, owned, controlled, and substantially financed, are distinct. So even if one of the three is satisfied by a body, it would be sufficient to declare it a public authority. What sets apart the RTI Act is the fact that for a common man, it is cost-effective, time-bound, and not too complex in its application. So, if you're keen to know the status of your ration card application, an RTI application can be filed in the format prescribed by the Act, addressed to the concerned Public Information Officer or the PIO. You can draft the application in English, Hindi, or any other local official language, and you're not required to know the name of the PIO or to give detailed reasoning for placing such a request. Upon payment of a reasonable fees, which differs from state to state. So for instance, in Maharashtra, it is 10 rupees. you can expect a reply from the PIO within 30 days from the date of the receipt of the application by the PIO. The importance of the RTI Act, therefore, can never be overstated. Yet its implementation has been prone to challenges due to a variety of factors. One of them is its conflict, the conflict between right to information and right to privacy. In 2017, the Honorable Supreme Court of India, in the case of Justice K.S. Puttaswamy versus Union of India, held that right to privacy is protected as a fundamental right, as implicit under Article 21 of the Constitution, which guarantees right to life and personal liberty. Although the word privacy was not defined in clear-cut terms, it was observed that privacy is the constitutional core of human dignity, and it has both positive and negative aspects. In view of this judgment, the possibilities of what can be considered as private and protected versus public and accessible are endless. So, if a public official acting in such a capacity writes a letter to his wife, will that be considered as a part of public records and therefore accessible to one and all via the RTI route? Or will access to such a letter be refused on the ground of protecting his privacy, which is now a fundamental right? The second issue is pertaining to the recent amendment to the RTI Act. In 2019, the RTI Act was amended so as to empower the central government to set the salaries and service conditions of the information commissioners at the center as well as the state level. This move led to wide-scale protests by the opposition, which argued that this will dilute the RTI Act and will take away the independence of the RTI authorities. Mind you, the original act, that is the RTI Act of 2005, had defined the salaries and tenures of the information commissioners as fixed in terms of the existing benchmarks. The third challenge towards the implementation of the RTI Act is the sheer number of and the volumes of the applications and appeals being filed currently. This has called for the implementation of the often ignored Section 4 of the RTI Act in its true spirit, so that a common man is not compelled to file RTI applications and appeals to receive information. After all, citizens in a democracy are the real owners of the information, and therefore public authorities should ensure that information is disseminated widely and in such form and manner which is easily accessible to public at large. Digitization of the entire mechanism of filing and responding to RTI applications and appeals by each and every public authority is also the need of the hour. Very few public authorities have effective e-filing portals which are actually working, and a majority of them still accept and respond to the RTI applications by traditional posting system, that is your registered post and speed post. The COVID-19 pandemic has further accelerated the need to digitize the procedures governing the right to information from cradle to grave. Before I conclude, I want to state that free flow of information is the hallmark of any democracy. It is a powerful tool in the hands of the citizens to be vigilant, to hold the government accountable for its actions, and to uphold the rule of law. Without RTI, there cannot be freedom of speech and expression, and without freedom of speech and expression, there cannot be a democracy. And this is why, friends, RTI matters.